Should you choose to accept it, is to win your client's cases despite the most impossible odds. This message will self-destruct in 5, 4, 3, 2.
My name is Dan Callahan, and I'm here to discuss with you today who is responsible for injuries that arise from a dangerous road condition. One major cause of accidents and catastrophic injuries that we see involve dangerous road conditions. For instance, a road may have been paved inappropriately or not maintained well or even designed improperly that could give rise to an unreasonable risk of serious injury or death. The first question is, who's responsible for these dangerous road conditions? In other words, if you need to file a lawsuit because you're injured by one, who do you sue? That's actually a more complicated question than it may initially appear. Generally, a road is maintained by a governmental entity, usually state or local. An interstate highway, however, is maintained by the federal government. However, with respect to state or local, in the state of California, state highways and roads are built and maintained by a state agency, the California Department of Transportation, called Caltrans. However, while Caltrans plans for the roads and oversees their maintenance, the actual work is often done by contractors and subcontractors, often numerous contractors and subcontractors for just one project. How the process first begins is Caltrans decides to embark on a new project. It issues a request for proposal for various parts of the project, with detailed specifications for the scope of work to be done. And then companies bid on the opportunity to perform that work. Now, very importantly for our purposes, Caltrans requires that its contractors have or obtain very large insurance policies that will cover not only the state, but all the contractors and employees for any injuries and damages that may result or arise from the project. Now, depending on the size of the project, this could be an insurance policy for as large as $50 million or $100 million. Now, this is important to you as an injured claimant because lawsuits are all about money, and the insurance company is often the source of the money to pay for the damage sustained by a claimant. After you retain an attorney to help you recover for injuries from an improper road condition, one of the first things he or she has to do is file a government claim. This means they have to first go to the government agency that is responsible and formally ask it for compensation. Now, as you can imagine, rarely does a government accept liability at this stage. Depending on the jurisdiction, the time to bring a claim against a governmental body may differ. However, one universal truth is that the statute of limitations is often substantially shorter to bring a claim against a government than it would be against a private citizen or corporation. Now, this is dangerous because failure to timely bring a claim against the government will often lead to the government having a viable defense when you later file a complaint. Now, let's say you're unsure which governmental entity may have liability. You'd be well advised to file against each one separately. For example, you may not be sure which one's responsible for a particular road, whether it's a state road, a Caltrans project, a county project, or a municipal project. In that situation, you should file a governmental claim against each one. Almost always, the government either denies your claim or fails to respond, which is construed as a denial, in which case you must timely file your claim with the appropriate court in your jurisdiction. For instance, in California, you generally need to file your administrative claim with a governmental agency within 6 months of the incident. The agency has 45 days to accept or deny your claim. If it denies your claim within those 45 days, you have 6 months from the denial to file your lawsuit. If you fail to do so, your claim may be barred. Note that this is a substantially shorter period than if you're suing a non-governmental entity. So if the agency doesn't issue you a rejection notice, you must check the statute in your jurisdiction to determine the deadline to file a complaint. In California, by example, you have 6 months from the date of that denial. Another important issue to deal with in these road condition cases is governmental immunity. In California, it used to be that the government entities were always immune from lawsuits arising from dangerous road conditions. The law now is that they are not immune necessarily. They can be liable, but only if a plaintiff can prove, among other things, that the dangerous condition was created by the wrongful act of a public employee acting within the scope of his employment, or the public entity had actual or constructive notice of the dangerous condition a sufficient time before the injury occurred to have taken reasonable measures to protect against such injury. You'll need to develop this factual evidence to prove all of these elements, as well as obtaining a potential expert to testify on the legal concept of constructive notice, which is that a government entity should have known about the condition and what reasonable measures it could have and should have taken. So, these issues show why it's important to have a lawyer who's experienced in these matters. In California, if you don't file a governmental claim within the first 6 months or fail to file a lawsuit within 6 months after a governmental rejection, you're quite likely going to lose your case on procedural grounds, even if the agency was substantially responsible for the incident that caused your harm. Another danger is relying on an attorney who is not experienced enough to find the appropriate qualified expert witness who can testify about the unreasonable nature of the government conduct, or whether the governmental entity had sufficient notice of the dangerous condition upon which to base liability. Before filing a lawsuit, your attorney should try to find out who the contractors and subcontractors were on the project. This is important for 2 reasons. First, the private company that's hired by the governmental agency is likely the contractor who is primarily liable for the dangerous road condition. Second, that contractor necessarily must have insurance suitable to satisfy your claim. Upon filing a governmental claim, all states typically require that you sue every person or entity that may be responsible in the same lawsuit. You can't sue different defendants in separate lawsuits for the same harm because the law requires everyone who may have liability be joined in the same case. So there's no risk of inconsistent verdicts or more than one recovery for the same loss. Although you may not initially know which contractors were involved in the project, you can find out who's involved through a government request. You can also find out during pre-trial discovery and then amend your complaint to add additional defendants. Lastly, an interesting advantage to naming multiple defendants in a lawsuit is that they often turn on one another. Caltrans is likely to deny any improper road condition, but if it does exist, it's the fault of the general contractor, who in turn will deny the problem with the road, but if it exists, will blame the subcontractor. Now, jurors may become very sympathetic toward the plaintiff when they see a horribly injured individual, and the government entity and its contractors pointing fingers at one another. I've had personal experience with many dangerous road conditions. I obtained a $50 million settlement of a personal injury case, which happens to be the largest personal injury settlement on record in the history of the United States. Now, that case involved an ambiguous bike lane, which caused an inattentive driver to mistake it for a driving lane, thus causing serious injuries to my client. Now, in another dangerous road condition case I represented a bicyclist who was paralyzed from the waist down when his bike hit a protrusion in the road. The client first went to a law firm that supposedly specialized in bicycle law. That firm advised him to settle for $250,000. Now, he was understandably not happy with that suggestion, and he came to us, where we eventually recovered $15.5 million in settlement for him. So obviously, you can see from these examples how important it is to select the right attorney. For more information, please visit our website, callahanconsulting.com. Thank you.